In this section, we're talking about child support. And this is an important area to get right because it can be subject to modification during the entire minority of your children. So child support is so important that the statute, it has a whole chapter on its own in Minnesota statutes. It's chapter 518A. And we're going to provide the link for you as a part of the materials, but just understand that it is a really important chapter. So, in fact, modifications are so common that the Minnesota Supreme Court's actually set up a mini court system known as the expedited process that has its own set of statutes and rules just for child support and uncontested paternities. It's run by magistrates, and a magistrate is simply a lawyer who has contracted with the state to act as a judge on these child support issues. And so that's how important child support is, and that's how often modifications are entertained. And the way you get into the expedited process, it's when your child support order has been assigned to the public authority for collection purposes. And I'll be talking more about assigning your rights to the public authority, but I just want you to be aware of that's when expedited process takes effect. So let's start with some definitions. First, there's a definition of child, and that's been defined by statute, and that's Minnesota Statute 518A.26. And they have defined it that a child means an individual under 18 years of age or an individual under age 20 who is still attending secondary school, and secondary school is high school, folks, or an individual who by reason of physical or mental condition is incapable of self-support. Now, I had the situation, both of my kids was a little different from when child support ended. My son turned 18 in January, but he didn't graduate from high school until June, so his child support ended in June. And my daughter, she didn't turn 18 until August, but she graduated from high school in June, so her child support obligation ended in August. So that's just a distinction for you to understand. In Minnesota, the legislature created Minnesota guidelines for child support, and those are found in Minnesota Statute 518A. And what they did is they said that based on parties' joint income, that they've set out a graph on exactly what child support should be. So I just want you to be aware of that, and I'm going to talk more about that in just a minute. But the Child Support Guidelines worksheet can be found at the website on DHS, and we've provided that information, that link to that site for you. So, what is child support? Child support includes 3 different elements. There's basic support. Now, basic support means money, and it is, it's under 518A.34, it's defined. And so this is what it includes. It's the dollar amount ordered for a child's housing, food, clothing, transportation, and education costs, and other expenses relating to the child's care. It's pretty broad in its spectrum. And basic support, it does not include monetary contributions for a child's child care expenses or medical and dental expenses. So that's an important distinction. But since it's so broad, understand that there can be an overlap. And obviously, one parent can't be responsible for all of that and the other person just pay child support. But I just wanted you to know the statutory site that there is basic child support, so there is a money component. Next is health insurance costs. Just understand that the calculator only takes into account the cost of the dependent health insurance coverage. So since most parties go and have it when they have health insurance through their employer, and it says that there's single coverage and family coverage, what you want to do is you want to divide out what the single coverage is and just leave in what the family coverage is. And that's generally the amount of the dependent coverage, and that is to be shared between the parents. And that sharing between the parents that I'm talking about, that's called PIC's percentage. So that's another really important distinction for the calculator. And in essence, what they do is they look at what are the parties' gross incomes, and they add together each party's income. So let's say, parent A makes $2,000 a month and parent B makes, $1,000 a month. The total is $3,000 a month. And you have, so basically parent A, that $2,000 a month is 2/3 or about 30 or 60%, and the 1,000 is, about 30%. Anyway, sorry, you can tell I'm no good at the calculations. That's why I use the calculator. But it's easy enough to calculate what your PIC's, each of your PIC's percentages is. The importance of using PIC's percentages is that it defines the percentage of each party's obligation towards health insurance and child care. So then, in addition to the PIC's percentages, there are child care costs. And the calculator does it, but that worksheet also takes into account that one parent is going to be receiving a child care credit on their taxes. So it should be parent B that goes and gets the tax credit, and that's what's taken into consideration. And the amount they're going to receive on the tax credit is reduced, and then the PIC's percentage is applied to the net. And I realize that gets in the weeds, but that can be important if one of you is receiving the child care subsidy or things like that. So I just want you to be aware of there is this division, but it may not make sense for your family with other special circumstances. And then there's the unreimbursed medical expenses, and those are defined in child support, and those are based on your PIC's percentages. So if you have, say, 64% of the income, then you're going to pay 64% of the unreimbursed medical expenses. And that is considered a part of your child support obligation. Then there's something called extracurricular expenses for the minor children. This is not defined in statute, but I will say that the courts do recognize that the closer the parties have to a 50-50 parenting schedule, the more that they recognize that each party should be responsible for, usually 50% of the extracurricular costs, so long as it's in writing. And that's something that you would have to write into your judgment and decree if you're going to want it considered. So let's talk about the factors in calculating child support. I just want to give you a bit of a historical viewpoint on custody versus overnights. And it used to be that if you had sole physical custody of the children, you would receive child support, and it was based on a percentage of the other parent's net income. And we haven't done that since 2008. And so it was recognized in 2008 going forward, and it really took effect in 2009, but there were some instances of changes, that both parents have an obligation to support their children. And so what they did is they said, we're going to look at both parents' gross incomes. And the reason we look at gross incomes is the legislature and the courts agree that your number one obligation is to support your children. And so they do not, think that you should be able to do your taxes, before it, or your monthly expenses or anything like that. They found it was just easier to look at gross incomes. And that is a gross income before any deductions for any pre-tax dollars either. So it is important to not just look at a W-2, but also to look at an actual paycheck stub to see exactly what's taken out of someone's paycheck. And so that's gross income. And that's great for people who receive a paycheck. But then there's another section in the child support chapter that talks about potential income. And you can set the potential income for an obligor if that person isn't presently employed, and there are other issues related to that, but there is a separate statutory section, and I just want you to be aware of it. So I had a case where I had a fellow who represented him, and he had been a mechanic, and he had been making $80,000. And so, but he'd lost that job. I believe he quit. And then he's now only making $10 an hour at a different job. And so the court found that he had a potential income of $80,000 and based his child support on that. And the idea is that if someone it's called voluntarily underemployed or underemployed, that they can set child support on what it should be, and it's up to you to then go out and get a job where you're making enough money to be able to pay your child support. So in addition to potential income, then courts can also, they do a slightly different calculation if an obligor is self-employed. And then the calculation is not on the gross receipts, but they look at what are the gross receipts of the business minus the ordinary and necessary business expenses. And so it's an adjusted gross income. And I just want you to be aware of that obviously if you have those special situations, then you definitely want to be having a discussion with an experienced family law attorney to help make those calculations, and maybe even consider doing mediation to talk about, what's a reasonable amount that person should be paying for child support for their obligation. So that's the factors used in calculating child support. And I've already talked a bit about this, but just to reiterate, when you're talking about medical and dental insurance premiums, do make sure you do that calculation to figure out what the dependent part is. There's an interesting case, though, that I had, just to let you be aware of, because that was a situation where mom now had remarried and her husband was able to cover the children under medical insurance. But he had children who were already on his policy, the family policy. So it didn't cost any extra to cover these two minor children. And so the courts found, mom wanted him to contribute to the cost of that health insurance and wanted to do it based on the number of people in the family. And the court said, no, the contribution is zero because he can provide for these children at zero additional cost. So it can be an issue. It's why you have to lay your cards on the table and have those discussions about what is a reasonable amount. So understand, okay, we're still talking about child support calculations and how it's calculated. And I said how we don't look at who has custody of the children anymore. So what the court does is, what the statute says, is we're going to look at the number of overnights. So we're talking about parenting time that a parent has. And you're supposed to average the number of overnights over a 2-year period of time. And literally, I guess they want you to count the number of overnights. You don't necessarily have to do that, because you know that if you've got an every other week schedule for your regular schedule, that's pretty much 50-50. And so, divide 365 by 2, and so you're basically looking at each having 182 and a half overnights. And so child support then is going to be based on those number of overnights. Generally speaking, the statute says unless there's a reason not to, but that's kind of going down into the weeds of child support, and probably not something you're going to be looking at in your do-it-yourself divorce. I just want you to be aware of it. So then the third element that we're talking about, we've already talked about basic child support, and then we've talked about the medical, the health and insurance piece of it, and now we're going to talk about the child care expenses. And just understand the statute only talks about what are the work or education related child care expenses. And so they are talking about child care coverage can be if one of the spouses has gone back to school. In order for that person to be in school, you could end up paying for the child care expenses while that other spouse is in school. And it's just something to be aware of. Generally speaking, though, for most folks, childcare it generally falls into two categories. There's the childcare expenses while the children are in school, and then there's the summer. So for any child that's school age, you want to be looking at what is it for the 9 months of the year and calculate that amount, and then what is it for the 3 months when they need full-time care. And in that case, just add the whole thing together, divide by 12, and that'll give you an average amount over the year. And then understand that you're only responsible for your PICS percentage of those child care expenses for as long as they actually exist. So you want to be putting in the details. What I strongly recommend you do is, if you're doing that average method, there's no harm in actually putting your calculations. Remember how in school you were told, show your math? Well, show your math on how it was calculated, so that the courts, if the courts are going to be asked to make changes to your child care obligation, that they can easily figure out how the original calculation was made. So, when can you deviate from guidelines? Because, as I said, the legislature really wants you to use Minnesota guidelines in determining your child support. And honestly, on a do-it-yourself divorce, I think you're better off, and the court's more likely to sign your judgment and decree if what you're doing is calculating child support based on Minnesota guidelines. And in fact, I strongly recommend that you include that as an exhibit, which that Minnesota Child Support Guidelines worksheet. That's going to be the simplest way for the courts to know how it was based, and further, for any future modifications going forward, the court's going to know exactly what was used for that initial determination. Now, as I said, you can deviate from guidelines, but you have to include specific findings on how it's in the best interests of your children to deviate from guidelines. So I had a case where the judge found it wasn't in the best interests of the kids simply because they had an equal parenting schedule. The judge says, well, so what? Why shouldn't the kids receive the benefit of that additional money? So that sort of surprised us, and that'll give you an idea of some of the initial findings you need to make on that. But generally speaking, the closer it is to zero, meaning if the parties have nearly equal incomes and they have close to a 50-50 parenting schedule, so that a child support obligation is less than $100, then for sure you can say that neither party will pay the others. But then you're going to want to include some additional language regarding how extracurricular expenses are going to be covered for the children. And I just want you to be aware of that. The more it looks like it's being done in duress, that one person just doesn't want to pay child support, and that they've browbeat the other parent into accepting that they not pay each other child support, the less likely it is that the court is going to approve your judgment and decree. They feel very strongly that children need to be supported. And if you think about it, the public interest in having parents support their children is that one parent will not be going to the state and asking the state to pay child support for the children, known as, one of our public programs. And I'll also let you know that if one parent is receiving public support and you're not going with guidelines child support, I guarantee you the county is going to go back to court and modify the child support to be guidelines support. So I just want you to be aware of that. And since I'm talking about the public authority, if a parent is receiving any kind of public benefit, and I'm talking about NFIP, SNAP, WIC, or even, it's my understanding, it could even be energy assistance, then you have to notify the public authority of your divorce. And the self-help forms do have that notice to public authority, and I have talked about that in another section, but it's worth repeating. Make sure you supply that notice, because the county attorney gets really frosty if you haven't included them. And in fact, the county attorney has to approve your final judgment and decree, and that you have the terms right for the child support. before the court will sign it. So that's an important distinction. And so it is important that you find out if it is your spouse that's receiving the support. You need to know what county they're receiving the support from, and that's the county that you serve. And you need to make sure that you do an affidavit of service for that public authority. And just to let you know, the statute is Minnesota Statute 518A.44. But you will find the forms, and I want you to make note of it if there is any public assistance. So let's talk about modifications of child support. And again, you're saying, Susan, why are we having to talk about modifications? We're just trying to get the divorce decree done. Well, as I said at the beginning of this module, that modification of child support is one of the main reasons that people go back to court during their child's minority. And the statute is 518A.39. And so you need to understand that you can go back and modify child support when there is a significant change of the financial circumstances. That's why it's also really important to show your math, like I said, so that when someone goes back for a modification, the court can calculate what it was to determine whether there has been a significant change. And there is a presumptive need for a change, which means the court will presume that the original order is unfair if there has been at least a 20% change in the resulting basic child support. So I just want you to be aware of that language and that's out there, and that's how the courts are going to be reviewing any modifications. But I do want to give the caveat, this doesn't apply to seasonal workers. In fact, the courts have said that a seasonal worker needs to take into account that their work is seasonal. And I actually had this case. The fellow thought that, even though we based his child support on him being seasonal, so what we did is we took his income that he received during the season, and then we added to it the unemployment he received when he wasn't working, and then we averaged his income over that entire year. So he went back to court and he thought, oh, hey, I'm not working now, and so I get to reduce my child support during that off-season time. And the court said, no. You need to take into account your lean times, and you need to be setting money aside because his child support was based on what his average's income was over the year. So be careful of that. Then another factor you need to consider is cost of living increases, what we call COLAs. And if the county in particular you've assigned your rights to receive child support to the county, every 2 years they are going to bring a cost of living increase. And what it is it's a notice to the obligor that, hey, we're raising your child support, and the amount is only going to be maybe $20. It's based on the cost of living. It's based on the gross national product of all things and various other factors. The Secretary of State lists it every 2 years. So actually, a private person who's not having the county collect it can actually do the calculation themselves. But generally, you will see it when the county's doing it. And then it is up to the obligor to bring a motion if they believe that they have not received a cost of living increase during that prior 2 years. So I just want you to be aware that statute is hanging out there, and it will affect you after your divorce if you're paying child support or if you're receiving child support. So then let's talk about getting the state of Minnesota involved in collecting child support. And this is mostly, obligees that do this. But we've already mentioned that if an obligee is receiving public assistance, then the county is going to basically force you to assign your rights to them. They just tell you, you're assigning your rights to us, and they're going to collect the child support on your behalf. And if it isn't an amount that they agree is right, they will go ahead and modify it. But generally speaking, they're also going to do the monthly collection of the child support. They're going to contact the employer, And they're also going to, every 4 years, they're going to review that child support order to make sure it's still fair and equitable. So those are the things the county's going to do. And because of equal rights, due process and those things, the legislature said, well, wait a minute, you can't just do this for people receiving public assistance. And so you only have to pay $25 and have the county collect it. You're considered non-public assistance, but you can get all of those services also. So it can be a really good deal if the other obligor isn't someone that's going to readily pay on time and in the correct amounts. So obligors, be careful of that. Now, one of the things you can do is the two of you can reach an agreement. If neither of you is receiving public assistance, you can agree, this is the 21st century, that, you can either have the bank automatically send it to their bank account. You can have it taken out of your check and sent directly to their bank account. So there's things you can agree to, and as long as the support is paid on time and it's not more than 30 days late, then the county has no reason to get involved in the collection of that child support. As I say, though, that the advantage to the obligee also is, though, that the county will go ahead and do those cost of living increases to bump it up every 2 years. So it's a consideration. I just want you to be aware of it. The other thing, by having the state of Minnesota collect your child support on your behalf, is that there are costs involved, and the state of Minnesota will take a small percentage. And at the time that I am doing this, I believe that percentage is only 1 or 2% of the actual child support, and that's to run their programs. They've been given statutory authority to do that. So make sure at the time, if you're going to have the county collect on your behalf, that you find out what the obligation is going to be and what they're going to take from you. And not only will they take it from the obligee, but they will also take a certain percentage as an additional cost for the obligor, again, of them being able to do the program. And then the other thing you need to be aware of when the state gets involved is, if you're an obligor, make sure you pay your child support on time every month. Because if you don't, the state of Minnesota can go ahead and they can recover from your taxes any delinquent amounts of child support, and they can also pull any professional licenses or driver's licenses you hold, or even your hunting license. So they can pull licenses, and they can make it really difficult because, again, the public authority wants you to be supporting your children, not having them support your children, and that's the reasoning behind it. So there you have it. I've talked about the basic elements of child support, how to calculate it, what's included is child support. And as I said at the beginning, it is very important that you get your math right, because the court has continuing jurisdiction of this issue for the length of your children's minority. And if you don't get it right and the state gets involved, they're going to make sure it's right. So anyway, good luck. And if you have any questions, obviously this is another place where it might be good to consult with an experienced family law attorney in order to make sure your calculations are correct, not only for the establishment, but also for any modifications going forward. Thank you.